The Slido motion is, the ICC's complementary jurisdiction has produced tangible results justifying its aspirations. Agree or disagree? A reminder that you can vote on this motion by scanning the QR code at the back of the brochure with the camera of your mobile phone, or by accessing slido.com and entering the event code 3653103. The polls are now open. You can vote anytime throughout the panel. And a reminder that if you enter Slido, you can submit a question anonymously or with your name tagged if you prefer. And now I will introduce panel 2. If you can take to the bench, please. Our chair, Professor Diane Orentlicher, has been described by the Washington Diplomat as one of the world's leading authorities on human rights law and war crimes tribunals. She has taught, written, and advised widely on international justice issues, including at the U.S. Department of State. She will preside over a very accomplished panel, including Silvia Fernández de Gurmendi, longtime representative of Argentina to the ICC process and arguably a mother of the ICC, as well as ICC president from 2015 to 2018 and current president of the Assembly of States Parties. Tamara Taraciuk Broner, Deputy Director of Human Rights Watch's Americas Division, is joining us as well, and Dr. Tladi, Professor of International Law and International Constitutional Law at the University of Pretoria, and member of the UN International Law Commission, amongst other things. I turn the floor over to Professor Orentlicher. Thank you.
Thank you. I'm very grateful to the Nuremberg Principles Academy for inviting me to chair this panel, and even more for convening this very important program. Mike, I was wondering about that. As others have noted, 2 decades after the ICC began operating, this is an opportune, and I would add, very important time to assess its record with a view to applying lessons learned going forward. Turning to the subject of this panel, as Judge Sung and others have recalled, the Rome Statute not only created a permanent international criminal court, which is a phenomenal achievement in its own right, but it also sought to foster a new global system of accountability in which states played the primary role. To this end, the concept of complementarity, which has often been called the cornerstone of the Rome Statute, would play the crucial role. To the point I made a moment ago about the system, I remember in the early years of the tribunal, when it began operating, I would periodically have conversations with the first prosecutor, and when I referred to the ICC as a court, Luis would admonish me, Diane, it's not a court, it's a system. It's the system of accountability. And that's really what this panel is all about. As we know, the concept of complementarity holds pride of place in the preamble of the Rome Statute. And Article 17 ensures that the principle is not just aspirational. It legally limits the court's exercise of jurisdiction to situations in which national courts are unable or unwilling to carry out genuine investigations or prosecutions. Yet this juridical principle hardly exhausts the meanings that complementarity has assumed for the court and for its myriad stakeholders. For many of them, as well as for successive ICC prosecutors, complementarity is a dynamic vehicle for catalyzing domestic efforts to tackle impunity. And in this conception, complementarity provides the fuel that, if harnessed effectively, can help power a global system of accountability. Of course, even that concept of complementarity as catalytic has multiple meanings, many interpretations. And I'm going to just note 2 broad umbrellas. One is a sort of negative, sort of Damocles conception of the looming threat of prosecution by the ICC as a factor that might help spur local actors to act to tackle impunity in situations where they might be hesitant. The other captures a far more dynamic and forward-leaning conception of cooperation between the ICC prosecutor and key actors in relevant countries. The two go together in practice. The coercive dimension of complementarity can and sometimes has been used by the prosecutor to underpin his or her efforts to stimulate action on the ground. Because in a moment, I'm going to turn back to the relationship of complementarity between judges of the ICC and the prosecutor, I want to first acknowledge that key actors in implementing complementarity very much include domestic civil society and international NGOs. For many of them, complementarity is the concept that has spurred them to act and to act effectively to demand accountability from domestic judges and prosecutors, even when the ICC has been relatively remote in their situation countries. It's often those actors who have spurred progress, even when the ICC is not directly pushing them to do so. So as we assess the actual experience with complementarity, we must always take account of these crucial roles. Now, returning to the judicial actors in The Hague themselves, I want to bring into the conversation the point that has often been noted and is a common point of commentary by expert observers of the ICC, that the two conceptions of complementarity that I mentioned earlier, first, a juridical concept that limits jurisdiction, second, a catalytic concept that can be harnessed to spur domestic action and progress, don't always sit easily with each other. And in fact, the experience of the ICC has raised a number of really important and daunting questions, including whether the jurisprudence as it's developed by courts under Article 17 might inadvertently, of course, but might sometimes undermine the necessarily painstaking and time-consuming efforts of local actors to advance prosecutions in the wake of a debilitating conflict, for example. Even more complex questions are raised by the related issue of whether the court's case law on complementarity has constrained more expansive understandings of complementarity by encouraging, if not literally requiring, local actors to mirror the prosecutor's approach, when alternative context-specific strategies might be more appropriate at a national level at a specific time in a country's precarious political transition. So really, at this point, I want to just surface the complexities of the issues regarding complementarity, and for now, turn to our extraordinarily distinguished and insightful panelists to do an opening round of remarks, and then I hope I might be able to follow up with a few questions after, before opening the floor to other questions. So I'm going to turn first to the very distinguished Judge Silvia Fernández.
Thank you very much. Good afternoon to everybody. It is really a great pleasure to be with so many good old friends who have been part of this process for many, many years, most of the people here, and others who have joined more recently and have added new ideas to this incredible project. Now, I'm also very pleased to be able to continue today from this panel the conversation that we started in May, also here at the Academy, in another conference that needed to answer one question, which was, is the future of international criminal justice domestic? So, and I think only one panelist gave an unequivocal yes to this answer, but most went into accepting this emergence of a global system where many partners, the international and national partners, need to do their job in terms of accountability. But of course, there was a lot of recognition and a lot of praise for everything that is happening now at the national level. And of course, we see now a proliferation of cases that are being brought before justice, mostly in Europe, but not only. Actually, there was a presentation of one case that is being handled in Argentina on regarding Myanmar on the basis of universal jurisdiction. And of course, there were presentations on mechanisms that have been created on Syria, Myanmar, in order to collect evidence and preserve the evidence for future prosecution by national or international prosecutors. And also there were references about efforts by civil society organizations like CIJA, for instance, that is also collecting and preserving evidence for mostly national prosecutions. Now, of course, and there was 2 days conference with many national prosecutors around, so there was really a recognition that lots of things are happening now that didn't happen before. And actually, some are already talking about some kind of a renaissance of universal jurisdiction. So all this is very impressive, but what I find mostly impressive is the huge change in our approach, the huge change in our mindset. Now, we have gone from a focus and praise of internationalism and international justice to now a new focus and praise of national and domestic justice. Now, I think it's very interesting to see and assess why this happened, how this change took place, and because, of course, this change of attitude doesn't come overnight. And what are the challenges ahead in these new circumstances? Let's just go back, since we're talking about 20 years now, let's go back to the 90s. Remember the 90s. At the 90s, we had our focus of attention on international justice. ICTY, ICTR, they had primacy. Remember, they had primacy, and they could even ask national systems to defer from handling a case when that was in the interest of justice. Then, of course, the ICC was different. It was created on the basis of a complementary regime. But let's remember that at the time, many of us, many states, and many civil society organizations regretted this system of complementarity. Many of us thought it was an unavoidable but regrettable compromise and concession to national sovereignty. And indeed a compromise that it was essential in order to make sure that the ICC would be created at all. Now, I would say that already by the time of the entry into force of the Rome Statute, this approach started to change. The Special Court for Sierra Leone was created in 2002 to deal only with those who are bearing the greatest responsibility, with this idea that the rest would be handled by national systems. So there was already this idea of a division of labor. Then also, soon afterwards, the Security Council ordered the reduction of the mandate, reduced the mandate of the ICTY and ICTR, and said they should also focus only on the most serious cases. And that meant for the tribunals to design new strategies to give cases to the national system, to design strategies to monitor what would be happening at the national level. Again, here, there was already this issue of division of labor. And of course, the ICC also accompanied this new recognition of new strategies, and also it was surrounded by new circumstances. First of all, the ICC started investigations on the basis of self-referrals, remember this, which also affected this, had an impact on this paradigm of tension between international and national sovereignty. And here, again, we could see that this tension was not necessarily the case in all circumstances. And of course, also, there was a focus on by the first prosecutor, here he is, who in his initial policy papers also recognized that the court, by its global nature, could not address all cases and would need to focus on the most serious cases. And actually, he went on to really praise the regime of complementarity, saying, ideally, the court should have no cases, because it would mean that others were dealing with these cases. So we see how we went from great enthusiasm for international justice to a different approach, where there was this recognition that we needed to combine efforts. That even when the court would address a situation, it would only deal with a few cases, and that others would need to do the job to fill the impunity gap. So this new attitude came from a realization of limitations of international justice, slowly also a certain disillusion of the outcomes of international justice, but also, of course, as I said, these new circumstances that surrounded the start of investigations at the ICC, but most of it also was the impossibility to match the global aspirations of the ICC with universal participation in the Rome Statute. Of course, there were Security Council referrals, they were mentioned here, Darfur and Libya, but they were the exception. They were not necessarily followed by a lot of cooperation. In the current circumstances, in a very polarized world, it is very dubious that we will see many referrals anytime soon. We saw the veto on a request for a referral for Syria. We saw the impossibility for the ICC to deal with Myanmar. So this really showed that the court has global aspirations, but with 123 state parties, has not yet universal participation, and the court, of course, has not been vested with universal jurisdiction either. So the combination is necessary. The combination is the only way to have some accountability and to manage to have some pattern of accountability which is not yet there. So this really, we are seeing now, there is this emergence of a global system. After 20 years, we do see that there are more cases that are being brought before justice. Now, this brings some challenges. One of them, of course, is the issue of division of labor. And maybe some of the things that were said 20 years ago seem to be a little bit outdated today. I don't think we can say in the abstract that international justice will deal with the most serious cases and national justice with the others. That would sound a little bit patronizing today, and actually is not in line with the system of complementarity. Because if the national systems want to address the biggest case, that is absolutely what would need to prevail. But indeed, there will be, in concrete circumstances, we will have to see how cases are divided when we have both the national and international courts looking at the matter. And we see this now in Ukraine, for instance, where you see investigations that are being carried on by the national systems and the ICC. How the division of labor will be done, we don't know. We will see. We have to see. Now, of course, then there is an issue of cooperation. We have said a lot about the essential cooperation for international courts, that this is essential for them to carry on their activities. The same applies to national systems. And in particular, when national jurisdiction is being exercised on the basis of universal jurisdiction, the matters of cooperation and the challenges of cooperations are huge, are basically the same problems that are being experienced by the court, but even maybe worse, because after 20 years, the court has managed to develop systems to increase communications, outreach, cooperation, protection of witnesses, issues of languages. Some experience has been gained, but for a national system exercising jurisdiction, I'm thinking of Argentina or Myanmar, where the issues of cooperations are huge. So they need to be addressed. Actually, they are being addressed. And we are developing at this very moment a new treaty to enhance interstate cooperation for crimes against humanity, genocide, war crimes, and other international crimes. This is a well-advanced project. We will have the diplomatic conference to negotiate the treaty in May next year in Ljubljana, Slovenia. I'm advertising because I'm the chair of that diplomatic conference. But no, this is an important initiative because indeed the idea is to strengthen cooperation, interstate cooperation of dealing with this type of crimes. And of course, modernizing the system and bringing within the system some of these ideas that we see that are mostly used in Europe, but they are very good initiatives, like the joint investigative teams, for instance. So cooperation is one challenge. The second one is coordination. And something was said yesterday here. Although here I think we need to also bring things to perspective and to the real dimension. Yes, there is more going on at the national level. There's more going on at the international level as well. But let's recognize there is not a stampede of cases. We still, whether it is national or international, we have to accept that justice continues to be the exception, not the rule. Right now, we continue to see entire situations that are being unaddressed. And when they are addressed, it's only a handful of cases that are being dealt with. So, but still, it is very encouraging, and still we have to see how we coordinate. Here again, I think it is a case-by-case situation. We see, again, Ukraine gives a good idea or a good example of some sort of cooperation with the joint investigative teams, the famous JITs. We will have to see how it works, because this is done in Europe again, but this is the first time that also the prosecutor of the ICC goes into one of these joint efforts. So I'm not going to speak about that, but of course we will see how this how that works and what lessons we can extract from that. But I would say that maybe more important than coordination is the harmonization. The dealing with these type of crimes on the basis of shared or common standards. And here I think the Rome Statute has a huge role to play itself. It has already done it. So the standards, when I mean standard, is definition of crimes, certain thresholds of evidentiary standards, some common, international criminal principles, including defenses that can be used. All these ideas, if different actors are going to be addressing the same type of crimes, it is important that we are talking about similar standards. So this is hugely important. And that's why it is so very important that, for instance, those who are parties to the Rome Statute implement the Rome Statute locally, domestically, so they have this definition of crimes within their systems. That's why other efforts to develop, for instance, this new Convention on Crimes Against Humanity is also hugely important because it could also apply to those who are not parties to the ICC, but would adopt the same type of definitions, at least for crimes against humanity. So, yeah, no, I have only 2 seconds. And she was being very discreet, saying, shut up. No, but one thing only in terms of also harmonization and coordination, also, we cannot expect the ICC or even the prosecutor of the ICC to act as some kind of a chef d'orchestra. That's not the idea. But still, the ICC, with its jurisprudence, can also play a role in helping to have the development of these common standards. And of course, we see also some guidelines that had been issued by the prosecutor of the ICC together with Eurojust in order to help civil society organizations to do certain tasks for the collection of evidence in a certain way. And so they do not harm. And this is also addressed the issue of coordination. So, and I stop here. I think in this emergence of a global system, the Rome Statute has a huge role to play still as a central part to give some harmony and cohesion to the system through its provisions. And that's why it's so hugely important that we continue to promote the universality of the Rome Statute system in many ways. So I will continue here. I apologize for extending a little bit.
You hope, yes. I'm sure it was clear that she was kidding about what I whispered to her, but let the record reflect what I said is, I didn't use up all my time, so please take some more of my time. You're so brilliant. We are, as I said earlier, we have an extraordinary panel, and our next panelist, Tamara Broner, is going to, as I understand it, bring us down to the ground level and talk about how complementarity works in practice, focusing on the Latin America region. So please, Tamara.
Thank you, Diane, and thank you for the invitation to be here. I will try to bring a practical perspective to this conversation, and I'd like to focus on very specific aspects of the work in Latin America, particularly around the issue of complementarity and positive complementarity, as well as the need for political support, and to draw some lessons that hopefully will be useful for discussing the global mandate that the court has. Latin American states and civil society have been significant actors. There are 28 countries that are state parties. There are several efforts at the local level to implement the Rome Statute, and the court and the prosecutor's office have been involved in several instances. I'll talk more about 2 of them as examples throughout my presentation. One is Colombia, where the first prosecutor opened a preliminary examination in 2004. It was the longest ever preliminary examination opened by the court. It was closed in late 2021, and it looked at atrocity crimes that were committed during the country's armed conflict, including by government forces, paramilitary forces, and guerrilla armed groups. The other is Venezuela. Venezuela is a case in which it was the first time that several states collectively referred a case for investigation for crimes that took place entirely in the territory of another state party. And we have now one ongoing investigation and one preliminary examination on Venezuela. The investigation focuses on alleged atrocity crimes that were committed in the context of demonstrations and political unrest in Venezuela starting in April 2017. It's right now suspended because the government requested a deferral. But there have been other instances in which the court has been called to act and hasn't. In the case of Bolivia, there was a self-referred case concerning road blockades nationally that allegedly impeded the population access to medical supplies. that clearly fell outside of the court's mandate, and the prosecutor closed their preliminary examination in February 2022. In the case of Chile, there were multiple communications regarding alleged crimes against humanity and protests that took place in 2019 that were repressed in Chile, but in December 2021, the former prosecutor decided not to open an investigation in that case. There's also the case of Honduras, where a preliminary examination was announced in 2010 about alleged crimes against humanity in the aftermath of the coup in 2009, and that also was closed in 2015. And the last example I'll mention is Mexico, where the office has received communications about abuses. In 2020, the office indicated that it planned to report publicly about what was happening, and we're not aware of any further developments since then. Let me talk a little bit about complementarity and how it had played out. It has played out specifically on Venezuela and Colombia. I mean, everyone here knows that the court is a last resort and that it intervenes when domestic authorities don't investigate and when appropriate, don't prosecute. One important moment for this determination is a preliminary examination, and the OTP's primary goal during this time is to make a timely determination about whether the office should exercise jurisdiction. And to do that, they have to determine if the crimes are being investigated or prosecuted genuinely at the local level. So historically, however, the prosecutor's office has articulated an additional policy vote in this respect. And you talked a little bit about this, Diane. And that's the goal to catalyze national justice. And while this should be secondary to determining whether or not the ICC will investigate, we do think that it can play a crucial role for the Rome Statute system. It can help trigger important results and improvements at the local domestic level. And in doing so, it can maximize the ICC's impact beyond the situations and cases that it will prosecute. And a big difference between the prosecutor's office and us from civil society or other organizations is that the office has an authority to open an investigation if the national authorities fail to act. And in applying this very unique pressure, the prosecutor's office needs to strike a very, very difficult balance, which means balancing the opening space for national authorities to do their work while moving forward and proceeding with its own investigation. Sometimes the delay when the ICC action does not result in genuine national justice can instead provide space for domestic authorities to stall on their process, on the progress, and even to obstruct the work of the court. And in turn, this undermines the Office of the Prosecutor's influence with national authorities, and the office risks being seen as legitimizing the impunity in the country. An example is Colombia. When the ICC prosecutor has contributed to catalyzing some positive steps, it was particularly helpful to counter some legislative proposals in the country that could have been a setback for accountability efforts in the country. And even prior to the peace accords, it helped keep the need for accountability for army killings on the table, and it contributed to the development of certain strategies within prosecutors' offices and the advancement of investigations and prosecutions against low and mid-level army soldiers. What it didn't do at the time was the involvement was, I would say, insufficient for years to overcome the politically equivocal support that we saw in Colombia to prosecute high-level army officials in the country. This example, I think, shows both the potential, but also the difficulty to have success at the domestic level. We face, particularly in Latin America, many persistent obstacles to trying the most serious crimes before national courts. There's some clear objective factors like the absolute lack of judicial independence in Venezuela. And in these cases, many preliminary examinations should result in opening an ICC investigation. And there are some worrisome indications that the Office of the Prosecutor is moving away from this policy goal. In the context of preliminary examinations, for example, it closed the Colombia preliminary examination and more recently Guinea without, even though the proceedings in both places are very far from over at the national level. So in my view, the OTP should continue where it is merited to pursue as a secondary policy goal in its preliminary examination this process of effectively catalyzing national accountability. And also, I would say, not only in the preliminary examination phase, but in all phases of a situation when the ICC is investigating. To be effective, however, the ICC prosecutor needs to be strategic in this engagement and avoid premature assessments that could increase the possibility for national authorities to seek to manipulate the principle of complementarity. And in Colombia, for example, we raised concerns that the decision to close the preliminary examination with a cooperation agreement that did not include specific benchmarks and that was concluded with no prior consultation with civil society removed one very important factor that, it's obviously a very complex and multi-layered landscape, but it had resulted in some steps forward and some movement towards accountability. Another point that I wanted to make is that interaction and cooperation between the governments and the Office of the Prosecutor are essential to ensure success in a preliminary examination or in an investigation, and to help catalyze these domestic investigations. But these two objectives have to be very, very carefully balanced. For example, cooperation is obviously key to access material information about the suspects, the scope of the investigation, the nature of the charges, but you have to be very careful in doing that. In the case of Venezuela, for example, the current prosecutor in March went to Venezuela and he announced that he would establish an in-country office to enhance cooperation with the government and to accelerate the common work towards justice, and that's a quote. There was a lot of reaction by local organizations that raised concerns that the OTP appeared to be prioritizing cooperation and to support the domestic authorities' efforts to conduct their own investigations. At the time, the authorities were presenting a judicial reform that did very little to improve judicial independence in the country. And what ended up happening was that on April 15th, the authority, Venezuela, requested to defer the investigation. On April 20, prosecutor can notify the pretrial chamber that his office would soon ask the judges to reject that request. That hasn't been done yet. And there was some conversation about supporting and actively engaging domestic authorities, but it still remains to be seen how that critical balance will be struck in the case of Venezuela. And one final point I'll make is that to be effective, the office needs to continue strategic public information efforts. Transparency is a value in and of itself, particularly vis-a-vis victims and rights holders, but at the same time, it's also a strategic value. And, there are obviously limits to what the prosecutor's office can share, and undue lack of transparency does raise concerns for local civil society, for affected communities, for potential other partners that are pursuing national justice efforts. And going back to the example of Venezuela, the trip that Prosecutor Khan did raised concerns about the civil society, given that he primarily met with government officials and he held no victims with victims and affected communities, and that raised questions about the transparency of the process in the face of civil society. And I know I'm running out of time and I don't want to get scolded, but I do think that one key recommendation in this respect is to enhance reporting and public communication around the work of the Office of the Prosecutor, including, for example, by reinstituting the release of the annual preliminary examination report and by developing communication strategies that are tailored for each situation that can ensure that the findings effectively reach authorities, civil society, and the media. And, just to give you an example, in the case of Colombia, former ICC prosecutor Bensouda published an op-ed in a Colombian media outlet in 2017 explaining a definition of what command responsibility under Colombian law was, and saying that it could be interpreted as limiting the definition of command responsibility in the Rome Statute. And this was part of a very effective effort by the Office of the Prosecutor to raise concerns about legislative developments that could undercut accountability at that time. And finally, just a few words on political support and the risk of politicization of all of this that we've been talking about. And there are some lessons to be learned from Latin America as well on that. Of course, the risk of politicization runs across the court's cases, and it's not just about the Americas. And, I would say that while the almost unprecedented attention that the need for accountability and the role of the ICC in the context of the expanded conflict in Ukraine, has been positive and it's very much needed. There needs to be care taken to ensure that the ICC has the resources and the support of state parties across all situations under its jurisdiction. And in the Americas, I would highlight the case of Venezuela and its investigation as an excellent example on the importance of political support for documentation and accountability efforts, including through the ICC, while at the same time the inherent risks of politicization of the court's work. The investigation followed a lot of work by civil society in Venezuela, international organizations like ours, documenting abuses, particularly since the crackdown in 2014. At the regional level, there was a report by a panel of experts of the Organization of American States. There was the referral by these 6 states that I mentioned earlier. And internationally, right before the opening of the investigation, there were a couple of critical reports by a group of experts appointed by the United Nations Human Rights Council in a fact-finding mission on Venezuela that found, first, evidence of crimes against humanity in Venezuela, and second, judicial complicity in the abuses. And these 2 reports preceded the decision to open the investigation in November 2021. However, at the same time, the political support by some actors has shifted. This is in part due to changes in governments. Argentina, I think for the first time ever, withdrew a referral. In the case of Venezuela, after the change of government in 2019, the current new Colombian government has said that they may do the same thing. But meanwhile, interestingly enough, Venezuelan authorities have engaged with the Office of the Prosecutor since the beginning, showing that they do care about what's happening and providing information and showing that they are concerned about the progress of the investigation. So just a final thought, I think this speaks to the need for constant vigilance to protect justice and to prevent the role of the ICC from becoming a political tool. And to do so in the case of the Americas, for example, I think requires taking very careful steps during the investigation to ensure that the Office of the Prosecutor put victims and their quest for accountability, which today they can't find at home, first. Thank you.
Thank you so much for those really informative remarks. Last but never least, for opening remarks, the estimable Dr. Tladi. Thank you.
Thank you very much, Diane, and also thank you for the invitation. I have been on a self-imposed exile from international criminal law issues since 2019. A very significant year, that 2019. But when I received the invitation to come and speak, and I looked at who was on the program, this was a couple of weeks ago, I thought they are bringing the godfathers here. I better not miss it. So for that reason, I decided. The godfathers and the godmothers, yes, the godfathers and the godmothers. So I thought I better not miss it. So I'm absolutely delighted to be here. I will take a slightly different approach from my co-panelists. I will focus on the universal aspirations part of our title, of our panel. I guess the first place to start is, for me, when I think about universality, one, it's not an objective of the Rome Statute. Of course, it's a means to an end. The end, the objective is, first of all, if possible, a world without atrocities, and to the extent that atrocities happen, then there should be accountability, so no impunity. That's the objective. One thing that we often miss when we discuss this is what I think is a qualitative element of universality, or the aspiration for universality. It's come up in a couple of presentations since we started yesterday. Navi spoke about how the ICC shouldn't, and I think the phrase she used was the ICC should not protect its friends. It came up in Fatu's comments. It came up in quite a number of comments, and for me it's really important. If there's one critique I've had against ICL, against even pure general public international law, it's this idea of equal application of the rules, and I think it's really important. By the way, that means that in decisions on whether we investigate, how we investigate, and also how long it takes to open investigation, the only thing that should guide that choice, that should guide those decisions, are the facts and not the who, right? I know on this point we probably differ, but I would say my experience is that has not always been the case with respect to the ICC, and that's one point of universal aspiration, universal application that I think is important. So what are the pathways to universal aspirations? I mean, I think the first and most obvious pathway to universal aspiration is promotion of the ICC and the search to increase ratification, right? I mean, that gives you pure universality. So that's the one, the most obvious pathway to universal aspiration or universality, and I think the most important one. The second one is through Article 12.3 declarations, and we've seen a few of them. I mean, it's not pure universality, but it contributes in the sense that what it does is it extends the blanket of the ICC to situations that would otherwise not be covered, and so to that way it at least extends the reach of the system. And so in a sense, that's a second pathway to universality, and I'll talk about some of the dangers, or at least I'll mention some of the dangers in a little bit. The third pathway, which I think is also an important one, and one which I'm glad has been championed on this panel, and also in previous panels, is complementarity and positive complementarity. What I would add is that in general, when we speak about it, it's not always explicit, but in general, when we speak about it, we're thinking about state parties to the Rome Statute exercising jurisdiction. But I think equally important, particularly for the purposes of aspiring towards universality, is states that are not party to the Rome Statute also exercising jurisdiction. And I'll say a couple of things here in a bit. The fourth one, which you will not be surprised to hear, I do not like very much, I do not care much for, as a way of extending the reach of the ICC is UN Security Council referrals, and again I'll speak a little bit about those. So I'll just start with the first, an obvious one. I mean, it's it's almost a no-brainer, right? This idea of promoting ratifications, because it has absolutely no cost. So unlike the other pathways, there are absolutely no costs, and all that there are is there are benefits. Article 12.3 declarations, for me, do raise a number of issues. One issue that it raises for me is the question of resources. Because here the ICC has finite resources. And in a sense, states parties contribute to the resources of the ICC. And one of the questions that always come to my mind is the expansion on resources and sort of how decisions are made on where resources ought to be expended. One thing that I would say as far as Article 12.3 declaration as a means of sort of achieving or extending the coverage of the ICC is ought to be important for almost a precondition that the state making the declaration also makes a commitment to joining the statute, I think it will be really important. I know we've seen it in the past. I think we've seen it with Cote d'Ivoire, and we've seen it with Palestine. And I know that there are many European states that are putting a lot of pressure on Ukraine to join the statute for that purpose. And I think that's also very important. And I'm glad about that. The third pathway is one that I want to spend a little bit of time on, and I'll actually come back to it, but I'll just say a couple of things first about it, and that's the complementarity angle. I mean, it's important, first of all, because it promotes what someone, I think, on this panel and maybe before, has called one of the most important principles of the Rome Statute system, which is the principle of complementarity. It's also important for another reason, and this is something we don't talk about anymore. I mean, I think we used to talk about it, but we don't talk about it so much anymore. This idea of ensuring that justice happens close to the victims, right? And so I think that's another reason why the promotion of positive complementarity in this way is an important pathway towards universal application. And so remember here, I'm talking not only about exercise of jurisdiction by states parties. I'm talking in particular about exercise of jurisdiction by states that are not party to the Rome Statute. The other reason why I think this is an important pathway to universal application is that I think it also complements the first pathway. Right? It also complements the possibility of increasing ratifications. I think that a state is more likely to join the Rome Statute when they think their domestic legal system is geared towards investigating and prosecuting. And I think the reverse is also true. A state party is also more likely to engage in investigation and prosecution than a state that is not a party. There are certain conditions, though, again, that have to be that have to be met, or at least I should say, perhaps there are certain factors that would make this type of a pathway more conducive. And one of those, so Silvia, you mentioned it, is ensuring a degree of consistency in the standards, right? And so that means ensuring a degree of consistency in the national rules. Now, of course, an easy way is just simply to say, well, domesticate the Rome Statute, and there you have it. But remember here, I'm focusing a lot on states that are not party, and so that are probably not going to be likely to be willing to domesticate the Rome Statute, and so we have to think about other ways. And I'll come back to these other ways that we can ensure a degree of consistency and a degree of equal application or similar application of the rules. I won't say much about, I had planned to say much about the UN Security Council referrals, but I won't, in part because I see my time is running out, but also because I think a lot has been said. I think I've marked here that Christian said something about it, Louise said something about it, Bill said something about it, about the dangers attended to UN Security Council referrals, and in particular, I think it was Christian yesterday who spoke about the perception of politicization. I think it's a little more more than perception, since it is true, I think we all accept that the council, in making a determination about which situations to refer to, is guided often by interest beyond justice. There are other issues that haven't come up at this conference, but that have certainly come up elsewhere. No, in fact, they have come up. I think in the previous panel, they came up. The content of the resolutions themselves, right? So the content of the resolutions themselves undermine not only the legitimacy of the ICC, but undermine the ICC itself and undermine the objectives of the ICC. I speak here about the ouster of jurisdiction provision. Somebody mentioned earlier today, I think it was Bill that mentioned earlier today, the financing provision. And I would just add to that, I mean, I think the one that concerns me the most is the cooperation provision, which is, by the way, at the heart of the biggest problem, I think, that the ICC has faced. The discussion, the exchange that we had so with Chile this morning doesn't happen if the text of the resolutions is drafted properly, right? So I won't say more about that. The only thing that I will say as a final point on UN Security Council referrals is I'm quite happy that they're not going to be happening, because I think the harm far outweighs the rewards, and I would challenge anyone to tell me what the rewards of the particular referrals have been. So to come back to the complementarity parts and sort of, so I thought I might share just a couple of things that the body to which I belong, the International Law Commission, has been engaged in, which could sort of promote this complementarity and the standardization of rules and so on. So Silvia, you mentioned it used to be called, back in my day when I was still in diplomacy, it used to be called the Belgium-Slovenia, BLS, I think, Belgium, Slovenia, and the Netherlands. I can't remember what the countries were. Yeah, so I'm really glad that that's moving ahead. There is another instrument, and you also mentioned that, which, and I'm not quite sure what the relationship between them would be if they both are active, but that's the ILC draft articles on crimes against humanity, which obviously is very important for enhancing complementarity, not only because it promotes investigation and prosecution, but also because of the reasons that you mentioned. It also promotes interstate cooperation. And in fact, I think that's probably the most important part of it. There are a couple of limitations, a couple of substantive limitations that I'll just mention as far as that one is concerned. So one is that the scope of the text, and I was the lone voice in the ILC that said, like the MLA initiative, which used to be called something else in the past, like the MLA initiative, it should have a broad scope. It should cover all the Rome Statute crimes, and by the way, that includes the crime of aggression. So that's one substantive limitation, and I'm not convinced by the response that the ILC has given for why it hasn't gone, but they've given some response. The other substantive limitation is that it doesn't address what I think is the critical question for the purposes of standardization, and that's the question of immunity. That is not addressed at all. My hope is that this particular process will also move forward, and I don't know what that means again about the relationship, but I hope it will also move forward. My understanding is that a resolution was tabled by Mexico just a couple of days ago, which would hopefully see it moving forward. And the beauty of it moving forward, and I will finish, so I will be within my 15 minutes, and the beauty of it moving forward is that states will then have the possibility of addressing some of the deficiencies that I have noted here concerning scope, and I hope that that's addressed. And I also hope that the question of immunity is addressed explicitly. Of course, the big question that arises if, as soon as you say the question of immunity addressed explicitly is, well, how should it be addressed? What should be the content of that? I would simply suggest on that the other topic of the ILC, the draft articles on the immunity of state officials be followed, and in particular draft article 3, 7, and 1.3. And I'll stop there. Thank you very much.
Thank you to our distinguished panelists for those fascinating presentations. We now have approximately 30 minutes for discussion, which our chair will facilitate, I think first with some discussion amongst the panel members, and then it will be open to questions from the audience, and I will convey a few questions from online as they come in. Thank you. I'll turn the floor back to Professor Orentlicher. Thank you.
Thank you. I'd like to just ask one follow-up question for each panelist, and hopefully a brief follow-up question. So, Dira, one thing I was wondering as I was listening to you talk is, in the transitional justice field, there's sort of an acute awareness and discussion about course correcting ourselves for imposing a kind of standard template on all countries. And so there's been a lot of movement away from that approach. So when you were talking about the virtues of standardization, I was wondering whether there's another side to that in your mind.
Yeah, I mean, I think so standardization makes it possible for states to speak to each other. For example, I mean, I'll give you a couple of examples. It's very difficult to ensure interstate cooperation when states have a different understanding of the definitions of crime, for example. It's very difficult to ensure interstate cooperation when states have different rules concerning immunity. So that's what I'm talking about. The idea is not that everything has to be exactly the same. And again, this is in the commentary on the draft articles on crimes against humanity, explains that there is some leeway for states in sort of, assuming that they would adopt this treaty, for some flexibility, but that at least sort of the broad structures of the system, the broad structures of the rules have to be consistent with each other. And I think that's what I mean so when I'm talking about standardization.
Great. And Tamara, my question for you also comes from a transitional justice lens. So in the transitional justice field, there's a really acute understanding of how messy transitions are in the aftermath of mass atrocities, and that progress isn't linear, and that there are setbacks and movement forward. And so ideally, in that kind of context, the ICC prosecutor, in the ways you alluded to, can engage in a very constructive, dynamic way to, I guess the ideal scenario, although I'd be interested in your thoughts, would be you have a prosecutor with a government that's supportive of accountability, but doesn't have all the political space in the world to do everything they want to do. And the prosecutor's engagement can widen that space, maybe not blow it wide open, but can widen that space and make it possible for the prosecutor to go farther than she otherwise could have. But you may have a moment where the leader of the country, the prosecutor says, we're now in a moment of danger. We would ourselves, if this were totally up to us, slow things down because we don't want to lose the progress we've gained. This is a danger moment. But let's say the case is now before a pretrial chamber, which is ruling on admissibility, and they say, look, inaction right now. We think the Article 17 standard is set. So the question is the standard too rigid? Should there be some play, and maybe I should ask a former judge that question. Should there be a more proactive jurisprudence for Article 17, or should there be any concession at all, or should that room for negotiation be kind of on the level of the prosecutor's engagement?
Look, I'll answer again from a very practical perspective with the two very different situations we have in Latin America. In the case of Colombia, since the decision to close the investigation was, or the preliminary examination was taken, there has been a report by a Truth Commission documenting abuses during the armed conflict. There has been historic progress by the Special Jurisdiction for Peace on certain cases, including involving top levels of FARC. The problem is that the definition of what the special sanctions will be that has been included in the peace accord is not really clear what that means. So there have been no convictions, and it's unclear what that would be, what that will mean in practice. So what I would say to that is, if the prosecutor had not closed the investigation, the preliminary examination on Colombia, it could be playing a super important role, tailoring these discussions and participating in the quest for accountability in a country where you can engage with authorities within the justice system and within the executive. In the case of Venezuela, it's entirely different because you have a country with absolutely no judicial independence, where the courts are not used to investigate crimes, even less so international crimes or human rights abuses. So what you have is not real, genuine cooperation, but attempts by authorities to try to show that they're doing something to stall the action by the prosecutor's office and the ICC. But I think to understand how that is relevant, we need to take a step back. It is obviously extremely relevant for victims to have possibly the only avenue for real justice available to them, which is international justice, if you don't have justice internally. But it also is a very important leverage in the political discussion for a transition to democracy and transitional justice more generally in a country like Venezuela, where authorities have not made any concessions voluntarily, and they have only done so when subjected to international pressure, and no one wants to go to jail. And they have no prospects of going to jail if the case is prosecuted by Venezuelan courts at the highest level and for the worst crimes. So I think there's an important role to play, at least what we've seen in Latin America, in both scenarios. And it's interesting because they're entirely different in terms of what you can ask from prosecutors, but it still can be extremely relevant in the broader purpose of trying to access justice and transitional justice and transition to democracy.
You didn't say this, but I might infer that you reject the premise of my question in most circumstances, and you made a much more important point. And then excuse me, I wanted to ask you, Judge Fernández, so some recommendations have been made that the ASP could play a more proactive role in at least linking national authorities with organizations that could provide technical assistance, and the point being that the ASP itself might be able to play a more active role in stimulating the kind of broad universality that Dr. Tladi talked about. Any thoughts on the role of the ASP in that regard?
Well, I'm not sure that this is really possible. I think the Assembly of State Parties has the quest for universality as a top priority. And because universality is hugely important, not only for effectiveness of the system, but also for legitimacy of the system. Because if not, regardless of what are the technical reasons, the fact that the court can address certain matters and not others does affect legitimacy, does give this perception of bias and selective justice. So there is no way around it. So I do think, actually, that it is hugely important almost as a goal of the system to become universal, because also it is a way of showing that the international community shares this value of justice. Now, what the Assembly does is really to try to reach out, and actually we do have what we call facilitators of the Assembly that deal exclusively with universality issues. And they try to reach out in partnership with some civil society organizations in order to engage with those states that may be willing to ratify the Rome Statute. So this is what the Assembly does, But the Assembly is also, you have to remember that the Assembly is not one institution. It's a decentralized body with representatives of 123 states. So it's basically an alliance of states, but we do not have, it is not an institution that can do training or that can do certain type of things. But of course, we could, through maybe sometime at some point through the Secretariat of the state parties, maybe try to do more. But at this point in time, what the Assembly frankly does is really to try to convince states to ratify the statute, and also to promote improvements in the system as a whole, in order to also show that the ICC, the court, has added value in a global system of justice.
Thank you. Jennifer, I'm going to turn it over to you to bring in some of the questions from the audience and online.
Okay. I would be happy to add a couple of those to start. One question that came in online, which perhaps is an extension of the discussion before, the ICC would be successful if it had no cases. The question was, would there be a point where the ICC stops existing if it had no cases? And perhaps that really is aspirational, but that was one of the questions posed online. Could you foresee a time, sorry?
Oh, no, there was just a bit of an echo, so if you could just
Yes.
repeat, we didn't.
Of course, yes. The question from online was basically, is there a possibility in the future the ICC could stop existing due to no cases? Or is an aspiration that at some point there would not be a need for an ICC?
I haven't thought very carefully about this, so this is an answer just from the top of my head. No, I think that the ICC will continue to exist, even in the ideal situation that there are no cases, because after all, the whole point is that if a situation does erupt, you don't want to now start and have to negotiate a new treaty. Or so I think there'll always be a need for the ICC, even so just as an institution, even if it didn't have any particular cases at the time.
Of course. Please.
Well, I think in an ideal world, there would be no crimes. No crimes against humanity, no war crimes, no genocide, and then we don't need an ICC. But since we are not yet there, I do think that it is quite impossible to think that there will be no cases at the ICC. And actually, in the real world, I think it is very important for the ICC to have cases. Despite all we say about complementarity, we continue to see that the ICC is judged or assessed by the number of cases it has, which is wrong, and not even cases, convictions, and that is, of course, wrong. But on the other hand, in order to really play its role as a backup system, as an incentive for others to do work, as a catalysis of national systems, as promoting certain shared standards, it is hugely important for the court to lead in a way it applies the law, and through its jurisprudence, I think it also helps in this standardization of standards, I would say. So I think it is important for the court to have cases, yeah.
I mean, just very briefly from my perspective, as a human rights defender, and the way we're seeing the world moving towards authoritarianism and closing democratic spaces in countries from ideologies from different extremes, I find it very unlikely that we won't have work to do. And in that scenario, I think it's an incredibly important tool to have, to be able to push for accountability, both internationally, but nationally as well.
So in the interest of interactiveness, the last two comments just made me think of one other thing. And that is, so in the ideal world that you thought about, Silvia, where we see a reduction in what we now call today crimes against humanity, genocide, My suspicion is that human nature and judicial nature, if there's such a thing, will constantly evolve such that our understanding of what falls under those crimes will change. And so it may well be that things that we might think aren't so serious are 100 years from now what the ICC tasks itself with. So I think the bottom line is that there'll always be a need for a court like the ICC, and once it's created, it's difficult for me to see it not existing anymore.
I see that there's a question.
Yes, Bettina?
Yeah.
Go ahead.
I'm Bettina Ambach, the director of the Vayamo Foundation, and I would like to confront the panelists with some critical observations from one of the situation countries and hear what you have to say to it. And just a background, so we have been working for 5 years now in Nigeria, exactly on positive complementarity trainings, trying to strengthen the domestic judicial system so that they can deal with the international crimes domestically. As you know, Nigeria is a party to Rome Statute, but has not introduced implementing legislation. So the issue of harmonization Silvia mentioned is still an outstanding issue, but that doesn't mean that they cannot do their work. As we all know, they use domestic penal law to deal with international crimes, which is quite a creative and difficult exercise, but it is possible. And 3 questions they always raise. So I'm just now repeating what we heard over the years. One is about cooperation and the antagonistic nature of it. So they were saying, why is the ICC in the preliminary examination phase, which now is concluded, and we are in that limbo of, is the ICC going to open investigation, yes or not? Why are they not telling us more about what we should be doing? You know, why is this such a general thing? They talk about the conduct, and why, if we are complementary, why are we not knowing more about what we should be doing? I'm not defending if they should be knowing what they have to do. I'm just throwing this at you and this discussion about, are we really friends or are we really antagonistic? And then 2 critical remarks they always mention about the admissibility assessment. So they had one case where in the Boko Haram cases, the ICC is looking at, the guy was convicted to 60 years in prison. It was the same guy the ICC was potentially looking at. Now the Nigerians very proud and say, look, he's in prison. And the verdict was for belonging to a terrorist organization. And then the ICC comes and says, no, not relevant for us. We are not looking into belonging to a terrorist organization, but we want to see the crimes the ICC has been created for. So Nigeria does not understand that. Third point, criticism about how high level are the people you're dealing with. Again, an important aspect of the admissibility assessment. Now, the ICC says, okay, you have 3 cases which in fact they dealt with. There was a trial, but they were not high-level people. So the ICC comes in and says, yeah, conduct relevant, but not high enough. So that's why we are saying it is still admissible. And now they say, yeah, fine, but we have not caught the higher level people. How can you criticize us for something, for a person we have not caught? Look at Kony. Kony is also still out there. You know, so I find this, I don't have an answer. I want to hear from you what you have to say to it, and I think it's an interesting question. Thank you.
They're asking great questions. Is there somebody who'd like to?
I do not have an answer.
You must have an answer.
I think this is a little bit related to what you said about whether the jurisprudence on complementarity is maybe too rigid and too narrow, in the sense that basically is based on a comparison of cases. This is the same case that is being dealt with by the ICC, and is basically a conflict of jurisdiction. If it is the same case, then the case would be inadmissible. But if it is not the same case, it would be admissible. And then we go into what is considered to be a case. And yes, well, I've been one of those who consider that sometimes focusing too much in specific incidents within, when we're talking, in particular when we're talking about massive criminality, like crimes against humanity, how do you really compare the cases? If the national state is dealing in a genuine manner with an incident that takes place in the north of the country, and then the ICC is looking to a very important case in the south of the country, but you are still looking at the crimes against humanity, and you are still looking at the genuine willingness to investigate and prosecute, isn't this system of complementarity too rigid? And well, there are several questions to this. This is a very difficult matter in light of the law as it is. And the law as it is indeed tells you that you need to look into this similarity of cases. Now, of course, and I don't know exactly the particularities of the situation that you mentioned, Bettina, but the thing is that the part of the definition of a case is indeed the conduct and the person. So if the national system is looking at different persons, of course we are not looking at the similar cases. Now, I don't think it is for the court, so I don't really understand what this comes from. I don't think it is for the court, and it has never been from the court, this attitude to say, oh, no, you should do this and you should not do that. And I don't think this has ever happened. And I see now the prosecutor of Fatou Bensouda saying, I think you are in agreement with me. So I'm not very clear why is this interpretation, because I cannot believe this comes from the court itself or even the office of the prosecutor. The national system is, they can deal with whomever, high or low, unless they are dealing with some individuals simply because they want to shield others. That's a different matter, but then we go into something that is not genuine. But if they're genuinely doing certain cases, I don't see how, why should the court be giving any kind of lessons? But I don't think this is probably a misinterpretation of the system. Another thing that you mentioned, this is a very difficult one, which is how much can the office of the prosecutor, I'm not a prosecutor, but from being there and from being at the court, how much the court can disclose to the national system. Because many times they come and say, well, tell us what to investigate and we will do it. And I don't think this is the type of information that the prosecution's office of the court can give. You do your investigations, the court does its own investigations. If the cases are similar, then the court will need to consider the cases inadmissible before the court. The judges will have to do that. But this is something that I know is persistent, to say, tell us what to do, and we will do it. And that is something that I don't think can happen very easily.
I will take another question from the floor, if that's okay, Philip?
Thank you very much. I just wanted to bring us back to one question I had in terms of positive complementarity, the evergreen, whenever you read the word complementarity. My question is this: looking at sort of how this whole thing has evolved. Positive complementarity, back at Prosecutor Moreno Campos' time, states saying, dear ICC, step away from all too positive complementarity. You're not a development organization. It's something for states to help each other. 12 years down the line, how much has happened in terms of states helping each other? I'm not sure a lot. And looking at the current situation of the ICC with a limited growth, if any at all, in the coming years, is it now maybe not the time to think again that what we have created with the ICC is one institution full of experts on a whole lot of things? You can say a lot about the ICC in terms of criticism, but it is one concentrated pool of experts. Would it not be potentially a good idea to think about how we can think back into positive complementarity, that maybe ICC employees to a certain extent can become catalysts of how states can arm themselves better in order to prosecute international crimes from all ends. And now I'm talking about something that is not just the Office of the Prosecutor explaining to situation countries how they should be positioning themselves, but maybe the entirety of the institution lending individuals here and there. So we're talking about the judiciary, the registry, in confines where it's actually more of a training exercise, and not just for situation countries, not just for states parties, but for the entire state community. So my question, is it time to think broader, or is it now better not to think about that at all? Thank you.
I'm going to see if any of my panelists want to, it looks like Dira will. Can I just make one observation on that? There is a model for this, and I suspect resources are going to be a big part of the answer why that model wouldn't work for the ICC. But Judge Fernández referred earlier to the ICTY practicing a form of complementarity in its later years. The motive there was that they had to wind down their work. They had an exit strategy, and that strategy focused on transferring a lot of cases to domestic courts. But in order to do that, the ICC judges determined that the local courts had to meet fundamental international standards of due process. There was a very intensive process of local engagement that was a form of capacity building. So there are models for that. But I will turn to Dira to solve the more complicated questions for the ICC.
Solve is a big word. No, I mean, my country was a focal point for complementarity and positive complementarity, I guess, at the time when I was a diplomat. And I remember the discussions that you're talking about, Philip. The sense that I got from those discussions was not so much that the ICC and its staff ought not to engage in activities to enhance positive complementarity, but rather that the resources of the ICC should not be expanded in that direction. What I see now actually happening is, in many different ways, the ICC being involved in this, but indirectly. I mean, a lot of the people that are engaged, even if they're not employed by the ICC, who are engaged in trainings and so on, have very strong connections with the ICC. So we know there are a lot of, I think Bettina's Wayamu is one, and I know there's a couple. So I think it is happening indirectly. The question is where should the resources come from? And I don't think that I personally don't think that the ICC ought to be expanding resources in that direction, but I do think that the ICC can serve as a facilitative place and forum where those that are going to be engaging in such trainings and so on can meet and exchange and so on. So.
I'll just add very briefly that, I agree it is happening. And if in the case of Latin America, for example, in Venezuela, the prosecutor has this dual approach of cooperation and an in-country office that is supposed to cooperate with authorities and also investigate. And I think the main challenge when you go that road is how do you keep the powers to investigate and the feeling that you're not giving that away because you're cooperating with, particularly in a context in which the system is not geared for real investigations, like how do you avoid being used as a tool to legitimize delays in national investigations that are in turn delaying international accountability? So I think it really depends on the context, and the challenge is if you're going to open that door, doesn't that mean that in part you're resignating because of lack of sufficient resources, the main purpose that is supposed to be investigation and accountability?
Klaus?
Thank you very much for this rich conversation. I've got a question that is related to a specific situation, but which is on substance fundamental in nature. The specific situation is that of Ukraine, where we are currently witnessing a multitude of activities on several levels. So we have the international investigations opened. Then we have the, call it the state most directly concerned, being very active on its own territory with, as Silvia has mentioned, new interesting practices forming joint investigation teams. And then you have other national states acting on, if you look more closely into it, different bases. But I leave it with the example of Germany having activated at its universal jurisdiction conducting a structural investigation. Now, Silvia has made the, I think, fundamentally correct and inescapable point. At one moment in point, there must be a division of labor. It is not, if I may formulate it cautiously, obvious to the outside observer that an exceedingly measure of coordination is existing now, and that there is a division of labor in one way or the other visible now. Silvia, you have mentioned there's perhaps not one size fit all rule, there might be different forms. So the question is, at what point should such a division of labor be made and communicated to the world? And there is a sub-question here. At one point, is it sensible in terms of practicalities, but also a legal question, if I may dare to say, under the complementarity scheme as it exists, at what point, at last, does the current law requires the actors involved to make that division of labor? Thank you.
Can we take another question before we round up some last answers? Luis?
Very small comment, because I like Diane. Remember, the idea is a coordinated system. I have many judges here, so it's a very good time to understand how the system working. For me, it's very clear, judges have the power, the full authority to decide on individual responsibility. And Article 17, as you mentioned, should be analyzed there. Decisions where to go, what situation to open, is different game. I think it's clearly prosecutor office. What I see in the 20 years of history, states are not challenging, oh, why you did that. Just the state mostly say why you have this office, oh, how much money. It's about budget. It's not about decisions. So the question is with Tamara. So you are asking for impartial decisions. How much Human Rights Watch is focusing on that aspect? Protect impartiality, protecting this IER, for instance, is obviously an instrument to reduce the prosecutor office exactly in this area of preliminary examination. How much the NGOs are protecting these basic standards on who are decision makers?
Okay, should I take that one? Look, we have at Human Rights Watch, as you know, we have a division that works on international justice, and what we have done is support a call for additional resources and political support to the court and the prosecutor's office generally, because we acknowledge the need to support the system. And, you know, I think that's the short answer to your question, which you don't like, and we can take.
The point about the protection of independence, for example, in the examination area. The protection from states or the judges invading the area of decisions, because how to enhance transparency of decisions.
Yeah, what I think is civil society has been supporting the system for quite some time, but it's not the job of civil society to be doing that exclusively, right? The independence should be protected by the states, and the job of civil society is to call on states to do that, as we do usually publicly and privately.
Thank you. I was hoping that someone would forget that there was a question from Klaus. No, this is an extremely difficult question because, first of all, it would not be proper for me to deal with the one particular situation that's been addressed by the prosecutor of the International Criminal Court. But I think I can answer this question in general. And in general, it's easier because basically we need to be informed by the complementarity regime. So in light of the complementarity regime, I think the factor that gives order to this, that at the end of the day will be the decisive factor in how the division of labor is made, is basically what is the national prosecutor and national system doing. Because that should be the starting point. Others can come and assist, and the ICC prosecutor is there, the other national systems may be also there in Ukraine, but other parts of the world. But at the end of the day, it will very much depend on what is the national prosecutor, what are the national prosecutors doing. Because if the national prosecutor takes certain cases, well, there you have your division of labor. The international prosecutor will not be able to look into these same cases, and I hope that also the other prosecutors, the other national prosecutors, will also respect these decisions. What I see in these and other situations where you do have people cooperating in doing the investigation is that, of course, I'm sure, I'm positive that they're talking and that they're exchanging some information. But at the end of when you said when is the legal moment when they should be announcing this to the world, I think this moment will come when they bring the cases before the judges, when they ask for an arrest warrant or when they ask for a summons to appear against certain individuals. That is the legal moment in our system, as I understand it. It is the moment where you announce what is the ICC doing. And of course, the national prosecutor will announce whatever he or she is doing in accordance with the national system. But I think this is a very, in a way, simple answer to a very difficult situation in practice. But I think in accordance with complementarity is very much based on what is done at the national level.
Can I just add one point, which is really, I think, to recall a point that I believe Fatou Bensouda made yesterday, which is that there is a risk in the meantime of putting an enormous burden on people who've already suffered an extraordinary amount. It's not just the national prosecutors that we've all talked about, but there are a lot of private actors and NGOs that are going to Ukraine to document work. I get emails from total strangers who went to Ukraine and want to investigate war crimes and give that information to the ICC and want me to advise them on how to investigate. There's an extraordinary and I think unprecedented coalescence of concentration of people interviewing, as I believe it was Fatou Bensouda noted yesterday, potentially the same witnesses, and there's a cost to that. So the time to resolve that in some ways is quite urgent.
May I address this because indeed I mentioned these guidelines that have been issued by the ICC prosecutor, I think, days ago. And these guidelines are indeed intended to address this matter of all these civil societies organizations doing great work, but also with the risks of destroying evidence or undermining the evidence, or actually this how do you say, re-traumatization by asking several of them, asking the same people to give testimony. So I think these guidelines are very timely and address exactly that. And actually the basic principle that is the first principle of the guideline is do no harm. But so these are very good, all very well-intended activities. But yeah, you need to put some order. But apart from giving these guidelines, I don't think anybody can do much more about it because you cannot prevent others to do. Again, the national authorities can do a lot to put some order in their own territory in terms of giving access to certain sites or to certain people. But once they are out of the country, then it is to be hoped that they will follow these guidelines.
Maybe I could just say as a last thought, because someone raised on Slido the question, how do you define tangible results? And I think that's a lot of what you're getting at, the question of applying consistent standards of some of these new models like the JIT and how that will work, especially in terms of facilitating dialogue, but also respecting the limits of the independence of the Office of the Prosecutor and of the judges, and hopefully building further trust between these potential partners through greater transparency. So thank you for that. And let's all join in thanking Professor Orentlicher and the panel for that fascinating discussion. And let's briefly return to Slido and the motion. The ICC's complementary jurisdiction has produced tangible results justifying its aspirations. Agree or disagree? 53% agree and 47% disagree. And with that, I conclude our second panel and welcome you to take a half-hour coffee break in the hall outside, and we will see you back for the last panel of the day at 3:30. Thank you.